Okay, hello everyone, welcome. Bonjour, bienvenue. It's my pleasure to welcome Justice Greenwood from the Federal Court of Australia here to the University of Ottawa Faculty of Law, hosting Centre for Law, Technology and Society talk about intellectual property. And it's my pleasure to moderate what will be an informal conversation with Justice Greenwood today. Justice Greenwood has been a member of the Federal Court of Australia for almost 15 years, appointed in 2005. And prior to his appointment had a career practicing law extensively in the areas of competition and intellectual property and other areas. He was a partner with Minter Ellison Lawyers, and in that role served on numerous committees related to antitrust and intellectual property in Australia and abroad. And as a member of the court has continued to play an important role as the convener or member of a number of committees, again in those areas of intellectual property and antitrust and other areas such as native title, and a member of the court's National Practice Committee. He is an adjunct professor at the University of Queensland and is here in Ottawa to celebrate the 30th anniversary of the Copyright Board of Canada.
Yes.
And so we are fortunate to have him with us this afternoon as part of his busy itinerary here in Ottawa for the next few days. So please join me in welcoming Justice Greenwood here to the University of Ottawa.
Thank you very much.
So we have about 75 minutes for our conversation today, and I thought that I would start the conversation by inviting Justice Greenwood to speak a little bit about his experience in the area of intellectual property on the Federal Court of Australia and what that entails.
Right, okay. So, as you probably know, the Federal Court is a national court. It's Australia's largest national superior court. And it's a bit unusual because it's a court that has an original jurisdiction, which some courts would call trial jurisdiction, but it's an original jurisdiction, and that jurisdiction is conferred upon it by a whole raft of general legislation, including, of course, all of the intellectual property legislation that you would be familiar with, and a large body of federal legislation, including the competition legislation and telecommunications and all sorts of things. But quite apart from that, it's got a general jurisdiction in any matter arising under federal legislation or arising in a commercial context. So it's a broadly based commercial court. So we're a little bit unusual as well because we have this original jurisdiction that we exercise, plus we have a very significant appellate jurisdiction, a Court of Appeal jurisdiction. And we're unusual because all of the judges of the court sit on the Court of Appeal in panels, obviously, not everyone all together. And so we think in our court that it's a perfect model because we think that anyone who sits on a Court of Appeal must have been at some point in their life in charge of a trial, running trials, understanding how trial judges decide things, understanding how juries work, understanding how decisions are made and trials are run. And if you haven't had the experience of running trials, big commercial trials, then it's a little bit artificial, I think, to come to courts of appeal and then sit on appeal cases where you have to decide where the error in the conduct of the trial arose, if that's what it is. If it's not that, it might be a straight question of law and you wouldn't necessarily need to have the trial background for that. But the blend of those two things we think is fundamentally important. So we sit in appeals for 4 weeks, 4 times of the year, so 16 weeks of the year we sit deciding appeal cases, and I'm about to come into the month of November where I'll be sitting in appeals in Sydney and Melbourne in intellectual property cases and other things. The second thing I would say about our jurisdiction is that I think is important is that the judges who are in the intellectual property national practice area, and there's a panel of those judges who are allocated to that area, those judges are not allocated exclusively to that area. So, for example, I sit in competition law cases, tax cases, commercial cases, corporations cases, and a lot of intellectual property cases. And that's very important because intellectual property rights properly understood, are just a species of people's commercial engagement and commercial rights. And we think it's very important that people bring to discourse about intellectual property rights a reasonably broad, well-rounded, holistic perspective about the way citizens engage and commercial citizens engage, and just what exactly is the true spectrum of disputation that happens between peoples in a whole range of areas of the law. We don't think it's necessarily a good idea to have silo experience with judges just doing intellectual property cases all of their professional life. I know that there's a debate about the virtue of single jurisdiction courts, intellectual property courts and things of that kind, and in the relevant circumstances that might work for some communities and some societies. But we think that if you accept the proposition that intellectual property rights are just a broad species of people's wider commercial rights, entitlements, duties, obligations, then it's important to have a broader perspective about the way that operates. And so that's very important for us. We see it at the trial level, we see it at the commercial appellate level, and we see it as part of our fundamental role to be across the jurisdiction as broadly as possible. The way we actually run the intellectual property part of the practice is that, or the court work, is that we have a national practice area. There's about 16 of the judges that are in that part of the national practice. Some of those judges will be doing exclusively patent cases because of the particularities of patent cases and the history and the taxonomy and the question of what is novelty and obviousness and all these other questions which have our own particular dynamics about them. Other judges will be in copyright questions, trademark questions, design questions, confidential information questions, whole rights issues across electronic formats and the digital agenda and such things. So there are 3 coordinating judges who run the national practice in intellectual property. I'm the senior coordinating judge. There are 2 judges in Sydney and myself, and we try to set some direction to those cases. We have a good look at the cases that are coming into the court for trial determination, and we have a good look at them coming up on appeal and try and form views about the best way of handling them. And we work in an allocation system to configure panels of 3 judges who will sit on the appeals, and we try to run what we would call a docket system so that the next judge in the relevant city who's on the list to do a case gets the next case. We don't try to select judges for cases unless it's a very unusual case. But by and large, we don't want parties picking their judge, so we have a strict clock system. The next case that comes in goes to the next judge. If it's a trademark case, it'll go to the next judge on the trademark panel who's up for that case. We would only ever overarch that system if we thought that there was a dilemma being confronted by a judge. Maybe there's a lot of reserve judgments to write, or maybe that particular judge is coming up for a big case, and we might then overarch that system. But by and large, we like to have a rotational system where parties can't pick their judge, and everyone understands that the cases get allocated in that way. So that's the way we run those cases. My own particular background was that I came out of a lot of work in intellectual property. I did particularly a lot of work in copyright and some particular aspects of patent work. Because I'd come from one of the very large commercial law firms, we acted for large public companies in the main, and so we were dealing with pretty significant intellectual property issues in the patent area and the copyright area for those companies. I did a lot of that sort of work, and one of the things that was a bit interesting to me was the intersection between intellectual property rights and the competition regime, because in our competition legislation we have a sluice gate mechanism that says that although we recognise that the bundle of rights that are conferred upon rights holders under the various intellectual property acts are what they are, nevertheless one could imagine situations where rights holders exercise those rights in a way which was conducive to an anti-competitive outcome. And so there's a provisions in our competition law that seeks to regulate the relationship between the exercise of intellectual property rights and the impact of the competition regime on that. And there's some protections that are built in for that, but they're by no means blanket. And so working out just exactly how that interplay operates, especially because in our provisions of our competition law, the provisions which regulate the abuse of monopoly power are very particular, and the copyright legislation and all the intellectual property legislation is not exempted from that. And so that intersection is quite important. As a legacy of that, I was involved in quite a lot of competition law cases, and as a legacy of that, I got into, as our Australian community evolved in relation to particular aspects that were confronting the society in relation to large-scale infrastructure monopoly assets like rail networks and gas pipelines and electricity networks, things that every community has to confront. I was involved in a lot of activities in relation to access to monopoly assets, large-scale infrastructure assets, and then how one would go about ensuring that users of those assets got access to those assets in a way which reflected fair and reasonable prices for access to those services. So in a sense that was tariff setting, and they were very interesting. They were very interesting cases, and they involved a lot of interaction with economic experts about the way one goes about setting tariffs for access to any bundle of rights, whether it's controlled in infrastructure or whether it might be intellectual property rights. That actually has been quite interesting to me, because one of the roles that I've assumed, having come to the court in 2005, although not from 2005, but I'm in the beginning of my early second term as president of the Copyright Tribunal, and I've just finished a term there. I will probably only do it for 2 terms. I think it should be rotated. But in any event, one of the things that's interesting to me is that when it comes to the plethora of copyright interests that are the subject of the statutory mechanisms for balancing intellectual property rights with access to users to those rights, there's a whole mechanism for statutory licences and licence schemes, and a mechanism for determining what would be a fair and reasonable equitable remuneration for access to those rights. And so the history of the way in which regulators have gone about working out what's a fair tariff for access to infrastructure, although not directly applicable, is in the same territory as working out and thinking about what should be the methodology for determining what's an appropriate tariff for access to intellectual property rights, or particularly, of course, rights under the Copyright Act. And our Copyright Tribunal is charged with the responsibility of determining those questions, although we don't do them in the same model that is applied by the Canadian Copyright Board. We have a very different way of going about that. So that background just tries to give you a bit of a picture about how we go about these things and where I've come from exactly, and where we sit now. So very much I'm engaged in the competition matters and the intellectual property things and the Copyright Tribunal things. And in the Copyright Tribunal we have at the moment about 6 really very major serious matters that are coming on for hearing and determination fairly soon. We have one coming up late January. One of those will come up for determination. It'll be a 2-week hearing in relation to what we call Crown use. So one of the largest state in Australia, New South Wales, is seeking to exercise a whole range of rights of the copyright owners, and so the Collecting Society is in great controversy with the state of New South Wales about what the fee should be for the right to use this whole plethora of copyright interests and rights, and we're going to seek to determine that question. And there's a large number of other very significant matters that are coming on. We try to get through these cases in about 12 months if we possibly can. And we have a very particular way of going about them, which is not the Canadian methodology, but every country has its own way of doing these things. But we try to make it as much as possible a consensual arrangement between parties. We try to bring parties together we try to bring about a consensual outcome if we possibly can. If we can't, we then invoke processes to resolve what are the contentious questions between parties. So that's sort of the background, really. Yeah.
Yeah, that's very interesting. A couple of points I want to pick up on. Let me come back to the competition issues and the administrative law issues in a few minutes. But I want to revisit the discussion of specialized IP courts.
Oh, yes, okay, yeah.
So in Canada, we are about to celebrate the 50th anniversary of our federal courts, the conversion of the Exchequer Court into the federal courts, Federal Court and Trial Division and Court of Appeal. And that has become sort of a de facto forum for specialized IP disputes, but IP cases are also brought in the provincial superior courts.
Right.
I'm curious what Australia's experience has been with around that discussion, whether to create even more specialized IP courts or not.
Well, there has been a lot of discussion about it, and so the way the federal court works, because we have this national practice area, which we call the intellectual property national practice area, in a sense we have a specialised court within a court. In a sense we have effectively a practice area with dedicated judges who do that work. But as I said earlier, we very strongly believe that it's important that the judges who decide these cases have broadly based experience. And I can tell you from just a practical day-to-day reality that a lot of the judges who decide these intellectual property cases, they don't want to just do intellectual property cases. They do want to be involved in some of the interesting commercial cases, and they do want to do tax cases because tax cases affect the whole broad spectrum of commercial interactions. And of course, a lot of those things are relevant to intellectual property regimes, about how the capital gains tax arrangements work and how that stimulates incentive and innovation. A lot of that tax policy in the legislation is very relevant to the way research works properly and the way it provides incentives. So we sort of have a halfway house where we have certainly a group of judges who are specialised because of their background and do focus on this work, but it's not that they don't just only do that, and they don't want to just only do that. Now, we have a lower court called the Federal, which is very confusing for the Americans. It's called the Federal Circuit Court, but it's not a Circuit Court of Appeal. It's effectively what we used to be called the Federal Magistrates Court, and a lot of the intellectual property cases of lower magnitude, if I could say, infringement cases and some relatively straightforward trademark cases and piracy infringement cases are all dealt with in that. Court.
And is that like a small claims court? I know there's discussion in the U.S. about the creation of essentially a copyright small claims court.
I think you could call it a small claims court, but they probably wouldn't like that description particularly. But
are damages limited? Is that the
there are
threshold?
caps on damages. There are caps on damages. So anything that's really of major commercial substance has to come into the federal court. There's an interesting question about the source of the jurisdiction, which I might just mention. So as you understand, of course, we have a federation in Australia, and therefore we have a central federal government, a Commonwealth government, which is given constitutional powers according to the heads of power conferred in the Constitution. And one of the heads of power that the Commonwealth enjoys is in relation to intellectual property statutes, the subject matter of copyright, patents, trademarks and designs. And of course then it enacted legislation relatively quickly from Federation in 1901. It enacted a suite of legislation essentially based on the English legislation, which then changed into adapted domestic Australian legislation. But the federal court, so the Commonwealth Parliament enacted that legislation, and there's constitutional power to invest state courts with jurisdiction in intellectual property matters, and the federal parliament could choose to do that, and it did choose to do that. Over time, it invested all of the superior state supreme courts with jurisdiction in intellectual property. But once the federal court came into existence, and once the reality bit that every appeal in an intellectual property matter from a state Supreme Court must lie to the Federal Court of Australia and our Court of Appeal, essentially, I think it's fair to say, there are virtually no cases filed in any state Supreme Court. They're all filed in the Federal Court. So the jurisdiction that was once exercised by the state Supreme Courts essentially has evaporated. All of the filings happen in the Federal Court, and that's largely, I think, because all the appeals come to our Court of Appeal. And the reason all the appeals come to our Court of Appeal is because we want a nationally coherent body of jurisprudence determined by a national Court of Appeal. We don't want episodic decisions from state Supreme Courts all over the country where different views are being taken about the jurisprudence, so that you then have to have the High Court of Australia settling disparate decisions between intermediate courts of appeal on the same subject matter. It's bad enough that you've got 6 states in the territory, so it's much, much better that the federal polity confers the jurisdiction on a national federal court where the trial division decides the cases, the Court of Appeal of the federal court decides the appeals and sets the jurisprudence, and to the extent that the Court of Appeal of the Federal Court of Australia needs correction by the ultimate highest court in the land, well, it'll correct it and establish the jurisprudence. But we know, we've looked very closely at that English London model of that separate court, and we understand it works pretty well, but those judges work only in that jurisdiction. That's all they do. That's certainly got the virtue that they get in, they get them done, they move on, they get them resolved quickly. We think we're pretty expeditious in our cases. We have a very vigorous case management process. We get these cases on as quickly as possible. Be very unusual not to have a trial in our court within 12 months of filing. That'd be unusual. It'd have to be a very large Apple Samsung type case or a very large pharmaceutical patent case that wasn't coming on quickly. And if it were that class of case, it would typically be on within 2 years, with all the international experts and the pharmacology people and all the rest of it. So we don't think that you need a single silo court to deliver efficiencies in the system or deliver timeliness in the system, because we think that's just not the experience. I'm sure if we did a proper empirical study of all the filings, you'd probably find there were cases that took longer than that. But I think that's not the experience in the last, I'm going to say, 10 years. One of the things I think is very difficult in this area is the sheer horrendous costs of the litigation.
Right.
It is not a place you want to be unless you are a resourced entity or unless you have a very high probability of success, because it's expensive. The adversarial process is one which engages people. You have to be committed to it. You have to be ready and willing to engage with the judges, engage in the case management, produce the material in a timely way. If you're going to have experts, you've got to have them on ready to go, and they've got to engage with the judge on case management conferences. So it's consumptive of resources. You need to be emotionally committed to seeing it out. You don't want to start any of these cases on the basis, it'll settle halfway through. Disaster. The costs in a large way are probably proportionate to the controversy involved, but nevertheless, it's a very expensive process. So a lot of intervention is necessary from the judges to try and crystallise what the real issue is and try and get to the meat of the problem. Every day in court's an expensive thing. So
who then do you find are the biggest users of those systems? Are they domestic actors, international actors? How do you see the parties who appear before the court changing in that context?
In my experience, we have a lot of litigation from Australian entities which are subsidiaries of or related to international entities. So, most of the really big cases are from overseas pharmaceutical companies, or they're from large overseas rights owners. And one of the things that's happened in Australia, partly because of our currency differential, but also partly because of historically, I think our costs have been a little bit lower than some foreign jurisdictions, especially anyone who's litigating a question like this in the City of London would brace themselves for the cost of it. But because we come from a stable democracy with a well-understood set of intellectual property rights, which are based on well-understood international conventions reflecting the domestic application of those conventions, and because we come from an adversarial system where the rules of the procedures are pretty well understood with a high degree of confidence, We have been a testing ground for a lot of cases in the pharmaceutical area, and things like the Apple and Samsung litigation, and a lot of those sorts of cases tend to get litigated in our court, and partly because I think that's where the questions are being tested, actually. And they get tested in a lot of countries' courts, of course, but we tend to see them quite early on, I think, in our experience. And then you have a range of Australian companies who exercise their rights in the usual sort of way. But I think a lot of our litigation in the IT area and the online area and the pharmaceutical area is from overseas companies, and of course all the major trademarks are overseas owned. That's the reality.
Yeah. I'm thinking of even cases in the copyright domain, early test cases like Sony and Stevens over technological protection measures.
Yeah.
To what extent do you think some of that might be driven by Australia's trade agreements? For example, the Australia-US FTA, where there's an alignment of relatively higher standards than other countries might have.
Yeah. Well, I think the answer is it's driven a lot by that, and those bilateral trade agreements, they worry me, I must say. They reflect a particular orientation which comes out of a particular view about trade distortions between nations, and it worries me, especially in the Australian context for the Australian-US Free Trade Agreement, that some of the United States-based entities have been agitating very strongly for a broader-based set of rights, and they agitate that the failure to accommodate those sorts of measures or copyright term or other things is not consistent with their understanding of the way those regimes should operate in order to give them the trade-related protections that they want. And so I think the circumvention measures particularly have been driven by that, very much so. And I understand that if you're an internet service provider, you don't want to suddenly find yourself liable for infringements or be stigmatised and therefore liable as having authorised infringements of peer-to-peer activities and other things where users of your conduit, which is all it really is, users of your service are using your service for conduct of their own, which creates infringements of intellectual property rights. I get that, but I can understand that an ISP who's providing a service doesn't want to be responsible for that conduct. It's slightly different, it seems to me, when the ISP is actually hosting on its servers the websites of the parties that are facilitating the activity, and even then there's protection. For that, but there's some triggers and traps in all of that, and it's about a question of the notification that's been given to the ISP and whether or not they've responded reasonably to relevant notification, and what is a relevant notification, and have they responded reasonably? What is determined? What do you factor into the question of determining what's a reasonable response? And we've seen that in that IINet case in the High Court of Australia, and of course the service provider, the internet service provider, was ultimately found. In fact, our Court of Appeal decided that it wasn't liable, and the High Court affirmed that, and I'm sure that decision is correct on the facts of the particular case. These things aren't ubiquitous in the sense you can say, ISP internet service providers are not liable. That's never the answer. It's a fact-specific inquiry always, but in that case, I'm quite sure that they were right, that they were not liable in those set of circumstances. But these bilateral arrangements do worry me a little bit. And the other thing that worries me about them is the dispute resolution, dispute settling mechanism.
I was just going to ask about that.
And that really drives me to distraction.
Well, we've had Australian cases over in the area of intellectual property over plain packaging, tobacco litigation that's been fought under two different international regimes. And the Australian Constitution. Canada shares a similar experience, having faced a claim by Eli Lilly for $500 million. Right. So do you want to elaborate on that at all? How do you see this changing the relationship between the courts and in dispute resolution panels?
Well, I think it's got the potential to make a huge difference, actually. So with the plain paper packaging, the idea that a sovereign government could legislate to require distributors and sellers of tobacco products to remove the graphics from the packaging and substitute it with very graphic photographs of people with throat cancer and lung cancer and in the last stages of decline from smoking, and then prohibit the sale of cigarettes, not prohibit the sale of it, prohibit the open sale of it. So if you want to buy a packet of cigarettes in Australia, you go into whatever the shop is that might be selling those, and you won't see a cigarette packet. What will happen is you will ask for a packet of cigarettes you want. The person will then get a key out, unlock a thing, pull a shutter up where all the cigarette boxes will be. They'll take one out and they'll give it to you and they'll pull the shutter down. So they don't even want the citizens looking at cigarettes. And that's because of the huge $36 billion public health bill that taxpayers have to pick up to deal with a lot of these problems. I don't know where that number comes from, but it's one of the numbers that gets thrown around. So, but my point is, the idea that a sovereign nation could choose to go down that path, and then, because on behalf of its citizens, and then find that by reason of a bilateral trade arrangement that's seeking to adjust rights between parties in the context of trade-related difficulties about intellectual property, suddenly find themselves in a jurisdiction where there's an arbitration triggered about the legitimacy of that law in the context of the bilateral trade agreement, with a view to effectively imposing pecuniary sanctions against the nation state because of its failure to accommodate what are perceived to be the central obligations of the free trade agreement, seems to me to be fundamentally horrendous, really. Now, if a nation state chose to enact legislation which absolutely seared through the centre of a bilateral trade agreement and took the bundle of minimum irreducible rights and then just extinguished them, okay, that's different. But like
a more classic expropriation case.
Yes, that's right. But just because Philip Morris and the others were not allowed to put their trademarks on their cigarette products, the idea that because the government had chosen to introduce a public policy position, the idea that you suddenly find a nation state caught up in an arbitration in Hong Kong about the legitimacy of that step in the context of a bilateral trade agreement with a view to very significant compensation for the loss of the value of the trademarks on those products seems to me to be not exactly consistent with the terms of that agreement. Which was, of course, is the end result of the way it fell out. But I'm a great subscriber to multilateral agreements,
right?
And I think multilateral agreements have served us well. I do understand that in the world of, globalisation, that maybe multilateral agreements haven't kept pace with the dynamics of some of that, and people might want to, in a bilateral way, adjust rights as between nation states for that. But multilateral agreements in the intellectual property area have been serving us well from basically 1883, when the Paris Convention on Industrial Property came to pass, followed by Berne in 1886, and then the sequence of amendments to them. And so I get concerned about these bilateral arrangements. I'm very concerned about the extent to which, when it comes to decision making under those dispute resolution mechanisms, the panels that are appointed don't necessarily have to apply the orthodoxy of the jurisprudence of a nation state.
Right.
They'll come to a resolution by applying whatever the mechanism they want to apply to that. How do you, if you end up in a situation where a lot of dispute resolution is done in that mechanism or through arbitration mechanisms where the jurisprudence of a nation state is not applied to determine the questions, how does a civil society develop its jurisprudence unless you're doing that through processes that have the discipline of a determination, then an appeal, and ultimately the highest court of appeal, where that court will establish a jurisprudence across a wide spectrum of rights, duties and obligations which citizens interact with. And I think this whole issue is particularly important in the general arbitration area too, because unless courts can come to a reasonably quick and efficient determination of cases and then deal with appeals in a relatively quick, efficient way within the dynamics of the particular case, of course, then parties will default to arbitration, because the one thing they buy with arbitration is finality.
Right.
And that's what they get. They get finality with an arbitration. Now, you might, and so long as you have the opportunity to influence the arbitrator and put your case and get your best experts and all the rest of it, and assuming you've got confidence and you've got the power to select your arbitrator, and the other side can select one of theirs, and then there's a third person generally. If you've got confidence in that system, the one thing you'll get out of it is finality, and what you used to get out of it was a very quick and less costly solution. Now it's no quicker. Our federal court decides things just as quickly as arbitration. So there are some arbitrations in some not particularly substantial commercial disputes that have gone on for a lot longer than commercial cases in the Federal Court of Australia, I can tell you. And it's not less expensive. It's just as expensive to go there. As the only thing you get out of arbitration now is finality. So that's something. But I think the weakness for a civil society is that if you have a lot of decision making that's falling outside national courts, where the public interest is engaged very strongly, then you're putting an element of your democracy at risk.
Very interesting. I'd like to come back to this point about civil society engagement and IP policy, because we've seen it around the world, in Canada and in the United States and in Europe and in Australia. I think actually a lot of that informs some of the findings of Australia's Productivity Commission and the Canadian parliamentary reviews. But before we get that, can we just talk a little more about multilateralism? Because I'm interested in the position of countries like Australia and Canada in the new multilateral environment. Right now at the World Intellectual Property Organization, there's talk of a treaty to establish minimum limitations and exceptions for educational institutions or libraries and archives. There's discussion about new protection for Indigenous traditional knowledge and cultural expression. So how do you see the role of countries like Australia and Canada shifting in those multilateral forums?
Well, historically, Australia's been a signatory to all of these major conventions. We, of course, became bound by them once the United Kingdom adopted them, but then once we elected to, for all the constitutional changes, to bring our own mind to bear on it, as it were, we adopted them and ratified them. And so Australia, through the Attorney General's Department, has always participated vigorously in these debates. And I think that Australia will undoubtedly continue to do that in all of these areas. And I think its preference, and I know its preference, is for multilateralism. There are a couple of these bilateral arrangements which have come to pass strictly because of trade-related issues, but generally the Commonwealth's position, and I know the Attorney has spoken about this not so long ago, is that he's committed to Australia participating as vigorously can in these multilateral arrangements. You talk about the Indigenous one, that's particularly interesting to me because in Australia, relatively recently, we've had a decision of the High Court which has established the common law right of native title in the Indigenous peoples in their various groups and clans in the various areas, and there's a sort of a set of principles that govern when a particular Indigenous group of people have native title. And in the federal court, we have the jurisdiction of deciding whether or not a particular Indigenous group of people have established a native title over the land in question. And as I was explaining earlier, Australia as a continent is effectively divided up to all of the federal court judges. So every single judge of the federal court has, although that's not quite true now because of what we've done, but not so long ago, every single judge in the federal court was allocated a geographic area and was responsible for dealing with claims by Indigenous peoples in that area. And we sought, again, to case manage those cases very vigorously. So I was responsible for the tip of Cape York, which is a very remote part of Australia, very large landmass. There were 28 claims in that area by 28 Indigenous groupings, the Lama Lama, the Ayapatu, and so it goes. And so we had to take over the resolution of those cases from a body called the National Native Title Tribunal. And that body was an administrative body. So what happens is an Indigenous group of people would file a claim in the federal court. It would be it'd be perfectly orthodox claim that one would make in a court of law, but then there was the Native Title Tribunal, which was responsible for undertaking the mediation of those claims between the various stakeholders, the claimant group, pipeline operators, mining companies, pastoralists, if there are rivers involved, the fishers, the fisher people, whatever. And we found, or the Commonwealth Government found, that those mediation processes and those negotiations were just ambling along ever so slowly, and some of them were taking 12, 13 years. And of course you had Aboriginal elders who were very disadvantaged, were dying before the claims on behalf of their people were being resolved. So the federal court was called upon to take over the whole case management of all those claims. And so I had 28 of those claims I took over in Cape York, and we case managed 26 to determinations of native title, which is very, very satisfying. And I've been into 28 of those communities, as remote as they are, and spent some time in every one of those communities. And it's been a most wonderful experience, I have to say. Now, in all of that, there is also the question of the Indigenous rights, to use a term, in the Indigenous work. And that involves things like very ancient rock drawings, the work of Indigenous people in terms of all of their artistic work, and most of those things, in terms of artistic work by Aboriginal people or craft work, all falls within the orthodox statutes. So they either qualify or they don't. But in addition to that, there has been a very interesting development which involves the idea of native title in, for want of a better word, intellectual property, right? So just as the common law was called upon to answer the question, as a matter of common law, do the Indigenous people in Australia have a common law native title to their lands based upon their long occupation and history of engagement and other things? In a parallel way, there's been a bit of debate about whether the common law should recognise or can recognise or should recognise that there is something in the nature of an intellectual property right in respect of Indigenous works.
Are there cases pending on that?
There
or is
aren't.
That so far an academic debate?
There aren't, and it's partly because I think it's quite difficult to sustain that position in the face of the Copyright Act, because the Copyright Act says, and it was quite deliberately done when the Root and Branch review of the Copyright Act was done in 1968, the Copyright Act says at its absolute foundation that copyright cannot subsist in anything other than by force of the Act, except for a reserved prerogative in the Crown in respect of a very limited matter.
We have the same issue in Canada.
Right. Now, a question might be whether, because the Act says that copyright cannot subsist in any subject matter other than by force of the Act, the question then is reference to these Mabo-like doctrines, this common law.
Yes.
Is that something that falls outside the notion of copyright? Is it analogous to a right in the nature of copyright, but not copyright, caught by the Act? And if it's a bundle of exclusive rights, or a bundle of rights which might be treated by customary law as exclusive in some respects but not others. So, for example, in relation to a lot of the work of Indigenous peoples, there are very particular cultural rules about who can do it, who can see it, at what age can a young person be before they're taken by the elders to see it, how were they trained in doing it, which particular individuals, women or men, young women or men, were selected to be the artists of the communities. So that's one thing. And another thing is that there's a lot of legislation in every state of Australia and some Commonwealth legislation, but most particularly this is a jurisdictional matter for the states, about preservation of Aboriginal culture and preservation of artefacts. And I think there's a good argument that a large part of the intellectual creativity and creative work of Indigenous peoples probably falls within the notion of an artefact anyway, just because of the statutory definitions, it's so broadly based. And then there are protections about who can engage with an artefact, who can take an artefact, who can deal with an artefact. So in a way, there's kind of statutory protections around a lot of that, which probably unconsciously attaches itself to works of Indigenous people. And I had to deal with this very particularly before I went to the court in relation to a very famous set of galleries called the Bradshaw Galleries. I don't know if you've heard of the Bradshaw Galleries, but the Bradshaw Galleries are a very old set of galleries in Western Australia. When I say galleries, they're drawings on rock walls in caves, which were discovered by a man called Bradshaw. And in his diaries, he describes these caves and he describes where they are. And so they were discovered, I'm going to say, in 1928, it's around there. And then his description of the site of these caves was sufficiently hieroglyphic and oblique that nobody could ever find them until, I'm going to say, the early 70s, a particular man found them. And in these galleries, there are the most beautiful drawings right through a whole series of these galleries, and they're of figures in the most lyrical, sweeping fashion. They really have very little relation to what one understands as traditional Aboriginal drawings from many of the Aboriginal communities that we're all familiar with. And it's largely thought that they were the work of probably Indonesian people who came down the land bridge before the oceans rose, and they came down the land bridge into this top area of Western Australia where these caves are, and maybe intermarried with Aboriginal communities, but certainly a lot of these lyrical figures are very like some Indonesian drawings you see in Indonesia. And they're dated, I'm going to say now, I think it's 42,000 years old they are, and the only reason they've been able to date them is because on the surface of one of the walls was a wasp's nest which contained organic matter, and they were able to carbon date the wasp nest, which was on the surface of these drawings, and so they knew that it had to be at least that old. And there's been 2 UNESCO conferences on these Bradshaw drawings to explain, well, what are they and how do they work and what have you. Interestingly, the Aboriginal peoples in the area of these Bradshaw caves have some mythology about not to go near those caves, keep away from that area. It's quite interesting mythology in some of the areas. Now, whether that was because of clashes between Indigenous peoples and people who come down through the land bridge, who knows? But that whole topic of rights of Aboriginal people is really very interesting to me. I'm involved in a project at the moment, which I've taken on, which is a comparison between the rights of Indigenous Australians as compared with the way in which the rights of North American Indians evolved. And I've had a meeting with the Osage and the Delaware Indians in the United States, and I've had explained to me exactly the history of those 2 tribal groups and how they were removed from their lands and the relocation, and then the treaties which the federal government never honoured. And in Australia we've never had treaties with the Aboriginal people, but there's very similar history of dislocation of Aboriginal people from their traditional lands and North American Indians from their traditional lands. And partly it was because they were pushed off their lands very often as white settlement expanded, but also it was that a lot of the missionaries, which were Lutheran missions or Anglican missions, by and large, sometimes Uniting Church Presbyterian missions, they relocated people very heavily. And so there's a long history of all of that, and it plays very much into determining who's got native title rights over other areas when large numbers of people were pushed off their lands, who lost their connection, not because of anything they'd done. And because a large part of the determination of whether or not a tribal group has a native title right is the question of whether they've maintained a connection with the land. But maintaining a connection with the land doesn't involve sitting on the land all day. It involves spiritual connection as well. So most of these Aboriginal communities are able to demonstrate they've maintained a totemic or anthropological or spiritual connection with their land in some way, shape or form. But that whole issue of the nature of intellectual property rights enjoyed by Indigenous communities is pretty front and centre at the moment, actually. There's a lot of discussion going on about that.
Well, that was a major focus of the parliamentary review of Canada's Copyright Act, a recognition by parliamentarians that there was a need to do something about the protection of Indigenous traditional knowledge, cultural expression. There's been debate in Canada as well about the extent to which intellectual property type rights might be already protected by Section 35 of the Constitution, which says that the existing rights of Aboriginal peoples are recognized and affirmed. So that's something that we'll have to continue to look at.
Have you had a debate in Canada about the relationship between those rights, however they might arise, and the Copyright Act, and whether the Copyright Act might extinguish them or might...
No, not yet.
No, okay.
But I say not yet because I think it's inevitable that question will arise. Whether it's 5 years or 10 years or 20 years, that's the next frontier, I think, in both intellectual property litigation and Aboriginal rights.
I think in Australia that issue went away a bit because in a couple of claims where this notion was actually being asserted, I think parties got pretty strong advice from QCs and lawyers looking at it pretty closely that it was a pretty fraught proposition ultimately, and was not likely to survive. And I don't think people were prepared to run it. But what you really need is somebody who's got who's prepared to run a piece of public sector, public interest litigation.
Right.
Which might be funded by somebody, but probably would have to be funded because although it's public interest litigation, our costs regimes don't lightly accommodate public interest litigation. Our cost regimes operate on the basis that if you bring a claim against a citizen and you can't sustain the claim and the citizen is vindicated, the defendant is vindicated, then prima facie you have a right to be paid the cost of being brought to court to answer this claim. And, unless someone's prepared to stump up with some funding on that could be a problem. But,
I think we're in the same situation in Canada.
Yeah.
I want to come back to some of the other things that were in the Canadian parliamentary report that I think parallel some of the issues raised by the Productivity Commission in Australia. Widely regarded internationally as quite a good document. Exactly, quite progressive, lots of good ideas in there. So around fair use or fair dealing, for example, in educational institutions, that was one of the big issues. Anything else that you pick up on in that Productivity report Productivity Commission report as worth looking at?
Fair dealing is a really important thing, I think, and we don't have a fair use proposition. Right. We have a fair dealing proposition, and there's a lot of pressure in a lot of directions from a range of stakeholders to move to a fair dealing regime, but it's not going to happen. I don't think the government is willing to do that. It's certainly looked at the fair dealing dynamics and tried to strengthen that a bit. That's. I just don't see that changing.
Do you see any risk of it sort of being walked back the other way?
No, I don't.
A tightening or a restriction?
No, I don't.
I know there's a lot of discussion in Australia about the Canadian experience with educational institutions in particular, and a lot of discussion. Not sure how accurate much of that is, but you don't see that as you see that as just as unlikely as an expansion of fair dealing to fair use.
It won't be wound back.
So more of a status quo.
Yes, and if anything, it would be loosened up, but it won't be wound up. It won't be wound back at all. Our educational institutions have we've gone through a change in the format, as you probably know. So, in relation to educational institutions, we used to have a very, very, very prescriptive mechanism for dealing with education institutions. It was called Part A and Part B of our Act, and it was shocking, really, and largely unworkable, and that's all been replaced by a new Part 4A, and it's much, much more flexible, and I think it's good for the universities and good for the educational sector, and it's certainly good for the Copyright Tribunal because it means that we can deal with those licence rights pretty quickly.
Yep.
And we've got a very big claim on at the moment in relation to 39 universities have got a claim on through the Collecting Society, and we've had an interim hearing about that, and we've had them in. So when the Collecting Society filed the application against the 39 universities, we got them in and had a couple of case management conferences about that. Tried to cut through to exactly what the scope of the problem was, and fundamentally it's a proposition from the universities that the nature of the royalty they've been paying in recent times, circumstances have changed so dramatically that royalty is no longer sound, and so their proposition is that because the existing licence has come to an end, there needs to be an interim licence put in place, and our jurisprudence is that when an interim licence is put in place, pending the determination pending the determination in the hearing, it's not part of our landscape to try and prejudge what the ultimate determination would be. We're not trying to work out what would be a proxy for the end result. We simply say, well, you are rights holders, you are users, you need to continue to operate between now and the hearing. What's the best, most reasonable licence arrangement to put in place to accommodate the competing interests of the parties pending that matter? And we don't try to make a pre-estimate of the ultimate result. So in this particular case, the royalty that had been paid in the last year was $32 million, and the universities said, well, we've looked at this closely. We know what the patterns of use are. We're satisfied that the royalty can be no greater than half of that, so it could only ever be about $16 million. So we're prepared to see that paid across as part of the interim licence now, pending adjustment at the end of the day when we understand what the final determination is. In the meantime, the other half, the $16.25 million, that should go into a trust account, be held in trust, should incur interest and accretions, and then if they're right, they get it. If we're right, we get it, or whatever it is, but at least it's preserved, because once we pay it across now, the Collecting Society has an obligation in its constitution to distribute, and you'll never get it back again.
Right.
So that's exactly what's just happened. So $16.5 million has gone into a trust account. 16's been paid across, and we're in the middle now of working out how quickly we can get that on for hearing. So. Yeah.
Very interesting.
Yeah.
We would be here all day if I asked all the questions I've jotted down during this conversation, but I thought maybe others in the room might have
Sure.
Some questions. Why don't we take 2 or 3 or 4 questions, collect them, and then turn them back to Justice Greenwood for discussion. So what do we want to talk about?
China.
Okay, we can talk about China. That's one topic. Anything else?
Sure. Could we drill down a little more on the fair dealing? Because it's not just the Productivity Commission, it's the ALRC as well.
Yeah, it is.
But I guess I'm curious about the disconnect between independent policy recommendations that have come through repeatedly in the Australian process and the opinion that is unlikely to actually happen.
Okay, all right, yeah.
One more?
I'm curious if Australia is experiencing the same thing that's happening here in North America with book publishers putting screws to libraries as we transition from sale of books to libraries to the direct licensing to libraries.
Well, that's a lot to chew on. So we've got changes in the consumption of books and licensing of libraries. We've got maybe related to that, but even broader, more about the fair dealing, and then of course the China question.
Well, I'll take China first of all. So China's been interesting to us. It's so the People's Principal Court has a relationship with the Federal Court of Australia, and we caucus with them quite a bit on various things. But the whole issue of reciprocity and national treatment is a big problem. I think the Chinese have established a wide range of intellectual property regimes, and they accommodate and afford foreign nationals the rights that are reflected in that legislation. And I think there might be some issues about recourse to those rights in a timely way. I don't want to say too much more about it than that, really. I think there's another issue in relation to the PRC, which is tricky from an international perspective, and that is that if you have a nation state that establishes something in the nature of a signals directorate within its military establishment, which is dedicated to systemically taking down the intellectual property assets of foreign corporations, that's a problem. And I can understand why the Americans particularly have been very agitated about that. So on the one hand you have regimes which recognise a lot of these sort of rights, and on the other hand you have conduct which undermines all of those rights. So I think that's a problem. So I can't say much about the booksellers, the book publishers and that dynamic, because in the Copyright Tribunal we just haven't seen that issue. It may come. I'm not across the issues between book publishers and libraries, but in the tribunal we haven't seen that come forward yet. But we may, and if we do, no doubt the dynamics of use and the basis for the calculation of licence fees will become a very real question, I suppose. In relation to fair dealing, I think the position we've got to with fair dealing is that there is just a sufficient body of stakeholder commitment to resisting fair use that I just don't think the government's got the courage to do much about that. I can understand the need for a more broadly based fair use provision, frankly. It's not for me to speak about policy questions. We apply the law. But if I were to be in a policy role, I could understand that the public interest might well be served by having a more broadly based fair use provision. Now, where the boundaries of that is, I'm not quite sure. But all of these things ultimately, this is something I'll be saying to the Copyright Board too, is that I think in all of these things you have to keep firmly in mind every time you come to any question about any of this is what exactly is the point, what is the principle we're trying to accommodate here. And generally speaking, it's a principle that's trying to accommodate striking a balance between the rights of owners, especially in circumstances where those rights get aggregated into collecting societies and get bundled together. What exactly is the best method for striking a balance between the bundle of rights which are conferred by the legislation and then perhaps aggregated together, and then how do you balance that with the rights of citizens and potential users who want to use that material for the purpose of engaging in some legitimate activity which is building on the shoulders of others, if you like, but may be in and around the territory of an exercise of a bundle of exclusive rights, but nevertheless is needed to enable people to do things. And we had this big debate in Australia about, universities and the primary research institutions in the scientific field being assailed by patent owners about use of patented material for the purposes of further research, and then seeking to prevent them from doing that. And I think that's where fair use in the copyright environment is actually quite a useful thing. I think you need to have an opportunity for citizens to engage with these rights, especially in relation to rapidly changing technological circumstances and digitisation and other things. If you just have a protective mechanism which is confined to various subsets of fair dealing, I'm not sure you're actually accommodating the broader societal interest you want. And, you know, we do want people to have access to material which enables them to do things that serve the public interest, but we don't want people, under the guise of serving the public interest, setting up structures and mechanisms that that represent wholesale infringement of people's rights. I mean, setting up websites with servers in various places that are just designed to strip down people's, you know, sound recordings or whatever it might be. That's not serving the public interest. That's just gaming. Mm-hmm. That's just gaming the interests of the community, really. And there are a number of companies out there that are dealing in people's intellectual property rights, really. And they're acting as intermediaries, and they're deriving a profit for establishing on servers processes which enable people to deal in the intellectual property rights of others without and running the notion that, oh, well, we're not infringing anyone's copyright, we're just an intermediary who's creating a buy and a sell transaction. They come to a website and they engage with it, and, you know, but so we're not doing that, and we're not authorising it.
So one of the big issues in Canada right now, big controversies, is to what extent there should be regulatory action to block those kinds of sites and services with, or much more problematically, without court oversight. Are you seeing these discussions happen in Australia as well?
Yeah, we are seeing those discussions.
And where are they happening? What sort of forum are those discussions happening in?
I know that they're happening within government, because I know that some parties that have been, let's use a neutral word, affected by those sorts of arrangements have been agitating that question with the Commonwealth government. But the Commonwealth is very good about these things. If it chooses to look into this issue in a proper way, which is what it always does, if it chooses to do it, it will put out a discussion paper and will call for submissions, and there'll be a debate about it. But there's been 2 cases in Australia. I sat on one of them. I was the trial judge in one of them, and I'm not making reference to this because I'm prejudging. I've decided my case, but Redbubble is a company, for example, which has a website at which people can upload the work of an artist. And if I'm an artist and I produce an artistic work and I upload it to a website, and that website enables a user to engage with it and then make various sort of tick-the-box selections where that artistic work can be downloaded and printed onto a cup or a poster or a T-shirt or something, well, that's fine. But if, on the other hand, I upload to that website a very well recognised international trademark, for example, well then, what's the position then? What's the position then if you're running a website that enables a person to upload a well recognised trademark, which is clearly not owned by the operator of the website, clearly not owned by the uploader, and is inviting someone to make a reproduction of that in a way which would fall within the test for infringement of trademark, let's say, because the seller is purporting to use the trademark in a way which would meet the tests, then is the operator of the website through its server in Boise, Idaho, engaging in infringement of the trademark? Mm-hmm. And how do you jurisdictionally attack that if you know, so if the work happens to be owned by someone who's you know, a buyer, let's say the buyer's in Australia and cites the work on the screen when they've gone through the various click processes, and you're trying to establish a jurisdictional link about the susceptibility of that party to remedial action in a national court where the servers are located somewhere else in the coast. Now, it might be that none of that ultimately infringes anything in the relevant case. And of course, in the case of Redbubble, they say, and they put a lot of evidence on, and no doubt they do. It's all accepted evidence that they have a whole lot of protocols that operate to govern those sites, to try and identify works which they would regard as infringing, and then they have a mechanism for blocking and doing things about that. But I think those sort of sites are going to be quite interesting because there's a lot of them.
Well, Canada's more recently dealt with this jurisdictional question, in particular the effect of its orders of the Canadian courts extraterritorially. That's something I think connected to the discussions that we're having right now.
Right.
We have time for maybe one or two other quick questions.
I have a question about how appellate courts go about reasoning, for example, to whether they do, and if so, how, consider changing commercial realities of intellectual property rights. But I guess I would refer to specifically trademark licensing and the purposes for which trademarks are being licensed increasingly. That changes the understanding of what the value in a trademark really is. And do courts consider that commercial reality, appellate courts, as part of interpreting, not as a fact, but as part of interpreting, say, statutory provisions. Like, for example, in Canada, we have constitutional doctrine of living tree, where the Constitution is interpreted in a evolving manner, and so it's quite different in IP. But do appellate courts consider that in interpreting statutes, and if so, how?
Well, I think the answer is they don't, is the short answer. So in Australia, the essential approach is a very textual approach. So the question always is whether the conduct on the facts falls within the statutory prescription for infringement of the relevant right. So if it were to be a trademark, you would look then at the tests, statutory tests for determining whether there's a infringement of the trademark, and you would then turn to the jurisprudence, the cases, which would illuminate the way the courts have approached that textual consideration. And the only context within which those questions you're raising would become into focus is if the remedy for an infringement were to be damages, then in the context of assessing damages for infringement, courts will look very closely at questions about licensing, valuation, what rights are in question here, how do you attribute value, how have they been diminished by the conduct, all of those sort of questions would then engage that. But at the threshold, the question is just a textual question for the statute. So, has someone used a trademark in the course of trade which is substantially identical or deceptively similar with the trademark in suit? That's the question. And on the facts, there's jurisprudence about how you meet those tests, and they're either met or they're not met. And if they are and there's infringement, then a remedy arises. And as a question of remedial law, the courts will look pretty closely at all of those questions. But in terms of understanding the nature of the right, it's a question of what the Parliament has said the law is to be, and we apply the statute in the context of the jurisprudence about what those terms mean and how you go about deciding whether that trademark is substantially identical or whether that one's deceptively similar or whatever it is. But there's a whole lot of cases, lots of cases about that.
Well,
So let me just wrap up our conversation then by inviting you to comment on this last question. Well, of course, the number one job is a textual interpretation. Those interpretations are guided by principles. And earlier you mentioned the principle of balance in intellectual property law. The Supreme Court of Canada has been, I think, at the forefront of courts worldwide in articulating that as the central interpretive principle, particularly in copyright. So I'm curious to what extent that notion may have been picked up by Australian courts, or if you're seeing that discussed more frequently or attributed to the Supreme Court of Canada. Is that making waves internationally? That's
I
what I'm
haven't.
asking.
I haven't seen that. I haven't seen that in the decisions of the High Court in recent times, I must say. I could have missed something. Maybe there's some discussion about that. I haven't seen it. In the jurisprudence of the Federal Court and in our Court of Appeal, we like to think we approach this on a principled basis.
Yep.
We approach it on a principles basis, having regard to what the High Court of Australia tells us is the method to be applied in determining whether there's conduct which contravenes a statute. And that's a very textual-driven thing. But of course, you have to construe the statute, and you have to understand what the purpose and objectives of the statute are to understand what the statute is trying to do in crafting those rights. The way in which we see the public interest arising is not so much in the construction of the language of the rights, because that's pretty well understood and the jurisprudence is pretty well understood. But where it really hits the road is in the remedial law. So when the question becomes, should you be restrained in respect to this conduct, the question then engages a whole lot of discretionary factors about that. And it's in that area where the courts will weigh in the balance a lot of those things. So you might find that someone's established a clinical infringement of an intellectual property right, but the question might be, and often will be, especially in the discretionary remedies, whether or not, as a matter of discretion, the remedy should go. This is particularly true in relation to injunctions and declarations that someone holds something on a constructive trust for the rights owner. And it's a little less true in the case of damages, because if a person has established an infringement and has a statutory right to damages and elects for damages as opposed to an account of profits, then we have to apply a methodology that goes to the calculation of damages. But there's a whole lot in that too. So I think it really comes at the remedial end, and that's why there's a lot of very important jurisprudence on remedial law, which is normative, not procedural.
Yeah.
It's truly normative, and it ultimately affects these things very, very significantly, because if you have a statutory framework which is talking about rights, duties, and obligations, then the way in which the remedial law impacts upon the adjustment of those rights, duties, and obligations is absolutely fundamental.
Unfortunately, I think we have to leave it there for the sake of the room booking.
Okay.
But we're very grateful for you coming here and sharing your time with us. For those of you who want to hear more from Justice Greenwood, the Copyright Board of Canada is celebrating its 30th anniversary this Thursday, and it may not be too late to RSVP for that. You can hear Justice Greenwood deliver the keynote lecture at that event on Thursday. Meanwhile, please join me in thanking Justice Greenwood.